sorry,
rhythm.
I'm the flow interrupter. Sorry about
That's
that.
right. You all good, my friend. You all good.
Thank you, sir. Appreciate
Um, yeah, for sure. Thanks for backing me up. So going back to what I was saying is, we take for granted that we understand what these contracts are. And so we decided to do this particular series. I did for the purpose of, bringing some knowledge and some understanding of exactly what these agreements are. And just as importantly, to see if we can create a way for you to weave these agreements into your conversations, or as you're having your conversations, have a clear understanding of what these agreements mean and how they can benefit you in terms of trying to get your deals closed. There's segments of this where you can inject, look, if they come up with an objection, oftentimes the objection is actually cured as part of the agreement, or the agreement gives you an avenue to cure the issue that they have, the objection that they might pose. So last week we ended on mechanics liens, and we talked about those. And one of the main points that was made last week about the mechanics liens is typically when it's contracted with an individual, it will stay with the individual, not with the property. But the first attempt is to attach it to the property. Usually, just a quick visit down to the courthouse in the municipality where it was issued. You can go right down there and resolve this, and move on, get that person off of there, have it follow them instead of following the property or clouding the title such that you cannot then close when you go to escrow. So that's something important to know about mechanics liens. Don't get too overwhelmed if the tenant buyer who is in the property contracts a craftsman or something to come in and do some work, doesn't pay the guy, and now the guy is posting a mechanics lien on the property. You simply have to show that, look, that person is not an owner of the property and thereby has no right to encumber. And you're good to go as far as that's concerned. So going on to number 33, dispute, disagreement. In the unlikely event that a dispute occurs or a cause of action in law or equity arise out of the operation, construction, interpretation, or enforcement of this agreement between owner and or tenant, the losing party shall bear the cost of the attorney's fees incurred by the prevailing party and any and all costs applicable thereto, including but not limited to court costs, deposition fees, out-of-pocket expenses, and travel expenses which are incurred by the prevailing party. So whoever loses pays all the bills. That's the bottom line in the case of a dispute. And we're going to go on and show how those disputes will be resolved. If the attorney find it necessary to resort to litigation, real quick, because a lot of times these are resolved through arbitration, which is basically a conversation with someone who acts as an arbiter, who is substantially less expensive than an attorney when you're resolving issues of this nature. So ideally, you always want to use someone who is going to just be an arbiter of this, and it's going to get resolved in that. If it goes to litigation, well, y'all know the deal. Now you're in the court, and now it has a lot of other expenses associated with it, not the least of which is attorney's fees. And also, he's going to take part of your settlement money, whatever is resolved, usually up to as much as a third or more. If the attorney finds it necessary to resort to litigation in order to collect the attorney's fees and expenses owed pursuant to this agreement, the client shall be liable for reasonable attorney's fees, costs, and expenses thereby incurred. Venue, you want to fill this in. Venue for any action shall be, and it will always be, in the city and state where the property is located. You don't want to put in, say, you're doing this remotely because, you're a virtual wholesaler, you live in, Illinois, and this property is in Louisiana. You put here where the property is located, not where you are. Arbitration, the parties hereby agree to submit said dispute to a commercial arbitrator so that the matter may be arbitrated in lieu of resolving said dispute in a court of law or equity. I mentioned this before. The parties shall choose an arbitrator from the American Arbitration Association pursuant to the following process. Needless to say, you can easily look up American Arbitration Association on YouTube, contact them, and they will walk you through the process of finding someone in your area to arbitrate your situation. The party shall request from the American Arbitration Association a list of 9 commercial arbitrators. Each party, assuming there are 2 parties to the agreement, shall have 4 strikes and thereby strike from said list the arbitrators they do not wish to use. So think of this kind of like when you're doing a jury process. If you've ever been on jury duty, they call you up, then they ask you a few questions, and then the attorneys determine whether or not they want to use you based on their perceived biases. So you may choose to use somebody based on your perceived biases, or simply because, well, there's something about the guy that rubs you the wrong way. So that is always going to be your choice, and that's how that works. So the remaining arbitrator, the one that has not been stricken, shall be the arbitrator and shall hear the matter. So you will each eliminate 4. So you have 9, you will each eliminate 4. The remaining one is the one that will be handling the arbitration. That's how that works. The parties agree to follow the American Arbitration Association rules, guidelines, and procedures. The arbitrator shall set the matter for hearing and shall control the procedures used therein. The parties shall abide by the arbitrator's decision, which shall be final and binding. The parties hereto agree that there shall be no right to appeal the arbitrator's decision. In the event the losing party refuses to comply with the arbitrator's decision, parties hereby agree to an award of $3,500 as punitive and or liquidated damages for said party's non-compliance with the arbitrator's decision. So the arbitrator makes a ruling. The ruling, you don't agree with the ruling. You decide that, no, I'm not following these directions. Well, you've immediately, struck a bill for $3,500 as part of this agreement, and it works both ways. Said party furthermore agrees to reimburse the prevailing party any and all attorney's fees and cost of litigation incurred in order to compel the losing party's performance in compliance with the arbitrator's decision. Basically what that means, the guy didn't comply with the arbitrator's decision. You ended up having to hire an attorney in order to get it resolved. The attorney, all of the expenses of hiring the attorney and the attorney's costs are now added to the $3,500 that he should have just paid in the first place. Again, it works both ways. So if you don't comply, you are now subject to the possibility of them going to get an attorney, and now you're going to lose. Whoever you're going to lose because you already had a obligation to pay. The attorney is not rehearing the situation. He's simply looking for this agreement for this agreement to be rectified, for everybody to do what they need to do. And whoever didn't do it, they automatically lost. Now you just have more expenses. The cost of arbitration shall be borne as follows. Tenant buyer shall be responsible for 50% and the owner will be responsible for the other 50%. Again, this is the arbitration, not the legal issue that occurs because somebody didn't follow the judgment placed by the arbitrator. So when it comes to the arbitration, you're going to go 50-50 on it. C, choice of law. Furthermore, this agreement is being delivered and may be signed in whole or in part and shall be construed, enforced in accordance with the laws of, can somebody tell me what goes there? Come on, you guys. I know you know what. I know you know the answer. Somebody unmute and tell me what they. Which state?
Where the house is.
Where the house is located.
Absolutely. That's exactly right. It's always the state where the house is located, because that's always going to be the government or the governing body that will deal with all of this. You can't deal with it from some other state using some other state's rules. So thank you, guys. Severability. If any provision of this agreement shall, for any reason, be held violative of any applicable law, and so much of said agreement is held to be unenforceable, then the invalidity of such a specific provision herein shall not be held to invalidate any other provisions herein, which other provisions shall remain in full force and shall affect unless removal of said invalid provisions destroys the legitimate process of this agreement, in which event this agreement shall be canceled. Okay, that's a bunch of legalese. Let me try to see if I can put it in plain English. If there's an element of this provision that is not supported by that particular municipality, say something in this is not enforceable, it typically is not going to be the entire agreement. It's going to be a section of the agreement. If that section of the agreement is unenforceable, that section can be stricken, but in so doing, it does not invalidate the remainder of the agreement. So that section goes out, everything else stays in force, unless by taking that particular section out, it affects the remainder of the contract such that it now becomes unenforceable under the laws of that particular municipality. I know it's a lot, but it's very important to understand that if something is unenforceable, you go to an attorney or you're sued or whatever, and that attorney says that, you know, this right here cannot be enforced. Okay, but we'll take that out. We enforce the remainder of the agreement. And in fact, there is an opportunity for you to reword a portion so that it does fit with the laws and statutes of that municipality. You can then turn around and put that into an addendum that now affects it and literally put it back in with the proper wording, and an attorney or maybe even a title company they can provide you with the proper wording, or you can simply find a contract in that area that is enforceable and replace it with the wording that they use in that contract. That make sense? Thumbs up would be good. This agreement, entire agreement, this agreement represents the entire understanding of the parties thereto, and there are no oral agreements, understandings, or representations made by owner or managing agent which are being relied upon by the parties. In other words, yeah, but you said, is it in the contract? Well, then it's not enforceable. No, this contract overrides basically any other, quote unquote, verbal agreements that, may come up later as, well, you said. Well, if I said it, it needs to have been written in the agreement. If you said it, it needs to have been written in the agreement. If not, it's not enforceable. Okay. The agreement of the parties, entire agreement. This lease contains the entire agreement between the owner and tenant buyer, may not be changed except by written agreement, right? So you can't go and make changes to this unbeknownst to the other party. Both parties have to be privy of any changes made to this agreement. The binding effect, this lease is binding upon and ensures to the benefit. This should be ensures. Let me see if I can actually put an S in there. Or is it? Yeah. Ensures to the benefit of the parties to this lease and their respective heirs, executors, administrators, successors, and permitted assigns. So in other words, if they ended up passing away, this is still binding to their heirs, to the executors of their estate, the administrators of their estate, any successors, and anybody who may have been permitted as an assign. How do you have a permitted assign? Anybody know? A power of attorney. C, joint and several. All tenants are jointly and severally liable for all provisions of this lease. Any act or notice to or refund to or signature of any one or more of the tenants regarding any term of this lease, its renewal or its termination is binding on all tenants executing this lease. Here's what I want to say about that. That's the reason, going back to when you do a tenant agreement for a tenant buyer, every adult in the property has to be listed. The agreement specifically lets them know that they cannot bring in sublease tenants. They cannot bring in any adult tenant that you do not know about, because every adult tenant will go through the same qualifying as every other adult tenant. You will have to have a credit check. Me personally, you do credit check, you do background criminal check, and you do tenant screening to find out if they've had any other issues with any other landlords. Have they skipped out on any other thing? So every adult has to go through that. And this is the reason, for the most part, why that is so, because they are going to be bound by all of the terms of this agreement, and they have got to know that they are bound by the terms of this agreement. So simply, sometimes when you're having a discourse, a issue with somebody, having a problem with the fact that they're going to move somebody in, you simply go to them and say, okay, well, let me tell you why is it so. If that person moves in, they will be subject to everything that you signed for in this agreement. And if you don't mind, can you pull out the agreement again and make sure that you review it with them? Many people will be like, yeah, I'm not down with that. I'm out. And if they are down with it, then now they have agreed by signing an agreement that they are also. So when it comes time to settle up, you can put liens, or you can go after everybody that's an adult that is in that property for recovery of damages. All tenants are jointly, okay, I think I just did that, yeah. Controlling law, the laws of the state. This one has Indiana because I did that on a deal. In other words, you can't write leases that you think are just, will cover every single thing, because the state law is always going to supersede whatever you think you know about contracts and whatever. So the easiest thing to do is obviously have an attorney in the area review the contract, or if it's usually a lot easier if it's a escrow title type state. Well, actually, I shouldn't say it's easier. The attorney's going to review this, right? The agreement at some point anyway. It's great to have an attorney involved in the agreement, and they'll look at it and they'll tell you whether or not something is enforceable in their particular area. Severable clauses. Should any clause in this lease be found invalid or unenforceable by a court of law, the remainder of this lease will not be affected, and all of the provisions of this lease will remain valid and enforceable. That's going back to the previous entry that was made about the binding effect of this agreement. Waiver. Owners or management agents past delay, waiver, or non-enforcement acceleration contractual or statutory lien, rental due date, or any other right will not be deemed to be a waiver of any other breach by the tenant buyer or any other term, condition, or covenant in this lease. Okay, let me read that again. Waiver, owners or management agents. Do you guys know, anybody know who the management agents is in an agreement like this? Can anybody tell me? Don't be shy, you guys. Hop on in there. If you're wrong, you won't be embarrassed.
Would it be the closing agent?
No, in this case, so you know who the owner is, right? Always the owner is the owner of record. And I say that with emphasis because there are times you'll get on the phone and you'll think you're talking to the person who owns the property, and they may actually even believe that they own the property because it's a family member, a parent, or somebody who's given them, who's put them sort of in charge of the process. They haven't done so legally, but this person is, and I'm sure you guys have made those calls where, I'm dealing with this for my, mom or my grandmother or whatever, right? They are not the owner, and they do not have the rights and privileges described in this agreement. The owner is the owner of record, the one that's listed in the courthouse as the owner of this property. Nobody else really matters, or nobody else is addressed in this. So if you find yourself in agreement with somebody who does not have the authority, this could come back and bite you. Hold on, let me turn off my notifications here. So make sure that, as early in the process as possible, you ask the question, are you the owner of record? And then you go as quickly as you possibly can, you verify that they're the owner of record. The management agent could actually, in some cases, be you, because you are the person who has put together the transaction with the owner and the tenant buyer. So you're actually in the middle right now. If you've promised the owner that they're not going to have to deal with certain things because you're going to handle it, you're managing the transaction as it progresses to a certain point until you step out. If you are doing a sandwich lease option, you're going to be the management agent all the way through until the house is sold and title changes hands. The other management agent could be if in fact it is being dealt with by a management company that was hired to conduct the transaction, take care of the property, fix toilets or do whatever. That occurs very rarely in a lease option agreement, right? Almost never, right? You wouldn't give your money to somebody, but let's say you did a lease option, a sandwich lease option. That sandwich lease option had $500. You live in California, the property is in Illinois. You're not going to deal with it. You find a reputable, good management company in Illinois. You break them off, 10% of the monthly rents. They are now the management agent. Okay, so I wanted to clear that up because it can be a little confusing, because you're like, yeah, well, I don't have a management company. Well, it could be you, and it will be you until the agreement is made between the tenant buyer and the owner, and you step off, you take your assignment fee, and you're off to the next deal. Or you stay in and it's a sandwich. Now you are still this person in the deal. Anyway, I think I made that understood. Owner or management agent's past delay, waiver or non-enforcement acceleration, contractual or statutory lien, rental due date, or any other right will not be deemed to be a waiver of any other breach by tenant or any other term or condition in this lease. Basically means if I agree to change your rental due date, it doesn't affect anything else. All it affects is the rental due date. If I, say that, there's a contractual statutory lien that's being dealt with, it doesn't change any other part of this agreement. Everything else stays in force. This is intended to be a legal agreement binding upon final acceptance. Read entire agreement carefully. Notice that is bold. And it is a message to, and really it should be a message to you, but it's also a notice to the person who signs this. And we all know, man, we don't read these contracts. How many phones have you bought? How many, what is it? Those little check boxes have you checked stating that you read it? Knowing darn well, but here's the protection for you. You actually stated and you made it in bold so that they would know that it is their obligation at this point to read and understand what the heck they're signing. Okay? If you do not understand the effect of this lease, consult your attorney. This should actually be, let me do this. Before signing, because once it's signed, now it's a little different process to go back and say, I didn't understand that. Yeah, well, it's a little too late now. Now everybody's obligated. Everybody is now needs to handle their business. Okay, and then you put the date that it was accepted. The date in numbers there, and the month and the year, which are obviously you'll modify according to the date. And then the tenant buyer and owner, you're going to be modifying these oftentimes to include as many tenant buyers as are necessary, so you may have to add some lines. And if there is more than one owner, you may have to add some lines for owner, but that's for you in terms of getting this thing done. Now, here is my favorite part of any contract, is the addendum. So before I go to the addendum, does anybody have any questions or anything regarding the first part that we went over, or any other part of the contract/agreement? Anyone? Okay, good. So here's the deal. If you have anything that you want to add or change or modify or extend or do anything that is outside of what we just described in the initial body of the contract, this is what you use. Even if, let's say, for example, you're doing a lease option. You kind of decide, I kind of like this place. Mr. Seller, would you be at all, open to, possibly doing a subject to on this? Perhaps would you be interested in acting as the bank on this, right? What you would simply do is you would take this addendum and you would modify it accordingly. And say, look, this agreement is an addendum to and here it says first right of purchase, right? But this addendum can be to, the lease agreement, to any other part of this contract. You will simply change this right here, okay? Between you or your company and the buyer, you are the buyer, and the seller on the contract dated such and such, concerning property located, and you put in the property address, okay? And then if there's any financial matters to be dealt with, you inject those there. The great thing about the addendum is that you can modify it in pretty much any which way you want to. You don't have to have anything in here. You can take out all of this that has to do with money or anything like that and simply put in, like, for example, an addendum after the fact, the person decides that they don't want to leave the appliances in the property. You use an addendum to say, appliances shall be removed. New tenant buyer will be responsible for providing their own stove, refrigerator, whatever, and they agree on it. Right? Or let's say I will leave the appliances in the property, but when you decide to move, if you want to keep the appliances, you will pay me X number of dollars. Very unlikely that something like that will occur, but if it does, this is the form that you use to modify or change the terms that are in the body of the original contract. Assigner, buyer, assignee, buyer, and seller understand that these monies paid to assigner, buyer also serve as assignment buyer's consideration in this contract and will apply to a purchase. That is, if you fill in this area here and there's monies associated with it, this right here, this little note says that that's part of the consideration in this contract and will apply to the purchase price as stated, in this case, the first right of purchase, paragraph 4. But let's say it doesn't. What do? You take it out. You take it out. If there is specific wording that needs to go in here, especially if you're in an escrow state, the best thing to do is call the escrow officer and say, I want to change this. I want to make sure I get the right writing. Can you send me over something that, shows how I should word this specifically? They'll typically just send you over something, from before, or they'll direct you to someplace on their website or something that you can have that wording that you need to inject into that space. Okay. These monies are not refundable under any circumstances. Notice how that's bold and underlined. You want to make sure that if there are monies that are non-refundable, you make it absolutely clear that those monies are not refundable. You will not be getting this money back. This money is down paid. There are obviously certain non-performance issues that could affect that, and you would still have to give it back. As an example, if in fact the property was supposed to be delivered vacant on a particular day, you actually have like 60 days according to this agreement to cure that situation. But for whatever reason, you could not get that tenant out, and now this person can't move in on the schedule that was promised. All of the monies are. So until that person does that, and even for a little while after, don't go spending your consideration. You want to hold that in a bank until everything on this situation closes. I would suggest that a minimum of 30 days beyond the closing date, just to make sure there are no issues in which you would now have to cut a check. So, just something to consider. And then you put the information there. Again, you can modify this to show where they can make how to make a ACH direct deposit, a wire transfer, a credit card payment, whatever it is that you will allow and are comfortable with, you can add here along with all of the pertinent required information that you need to have in order to complete the transaction, and you can just add that in there yourself. Cool. So I don't want to start on another agreement, but I do want to, if you guys have any additional questions about either the agreement, how to use it, how to introduce parts of it in a conversation, how to overcome an objection in terms of, being able to use this, anything like that, that's fine. If you don't have any questions about the agreement itself, we can go over any questions that you guys have for the next 20 minutes. If you want to review a deal or whatever, let's just pop on in here and let's get her done. Garrett, I don't think I've ever seen you in the room before, my friend. Tell me about you. I can't hear you. I don't think you're muted, but it's not coming through your mic.
Can you hear me now?
Yes, sir.
Okay. Hi, Coach Victor. Nice to meet you.
Likewise.
Brand new to the club. I'm inundated, or how do I say it? Inundated with so much information. Grateful to be to the club. Learning a lot. I've been wholesaling for past couple years.
Okay.
I am new to the creative side of the business. Been learning a lot. Just kind of still going through tons and tons of information, going through the videos and things of that nature.
Okay.
But I do have a question. I did not
Certainly.
see your previous sessions. Is this a lease option and purchase agreement, or just the lease option contract?
Yeah, this particular agreement that I went over with you guys today, we have in as part of the docs that come with the with one of the courses on the website, you'll see a I believe it's wholesaling lease options is the course. In there, you'll find what we call a full packet. And this is what this comes from.
That's in the agreements archive, by the way, just for clarity.
Oh, it's in the agreements archive. Okay, yeah.
So when you go into the agreements archive, that's where you'll find that particular package.
Yeah. So thanks, Justin. So a lot of the stuff has been updated, has been modified, has been changed. The reason why I'm actually reviewing this one, I have used this package. I have had this particular agreement challenged, and the agreement won. So that and you'll see that some things have been updated. Things change. Things.
I love that, dude. You can say that again if you want to.
Yeah. The agreement was challenged, and the agreement won. Okay, stop already. I thought I turned you down. So I'm, I got a call from an attorney, and the attorney was, telling me that I couldn't do this, or that this was illegal, and and that the tenant buyer didn't understand this or that. So, obviously initially I'm like, oh my God, this is terrible. You get all of that scared. So you imagine yourself in court losing and, them coming to get your house or whatever. But I just simply went back to the agreement with his signature on there. I especially pointed out the fact that it is his job to understand this agreement. The attorney obviously knew that part, right? It was his job to understand the agreement, and I pointed out all of the sections that she questioned me on. Never heard from the attorney again. Never heard from the attorney again, because I knew that the agreement itself was well worded, it was strong, and it covered the areas that needed to be covered in order for this to be rock solid in its commitment to both of our sides and what we were expected to perform. And so, we moved on from that. Everything turned out good. The person actually ended up purchasing the property and everything, down the road, because he basically at some point conceded the fact that he never read a thing. He had no understanding, and, he still wanted to blame me, but ultimately, he had to come to terms with the fact that it wasn't on anybody but him. And so he handled his business and he got the deal done, and he now owns the property. So, great story to tell. And this is why I use this particular agreement, because I know I can stand behind this particular agreement, because this is exactly the one that I used in that transaction. All of the other agreements are going to be variations of this, maybe rewording, and in some cases just condensed to where they're one-page contracts or, things of that nature. But if you cover all of these areas in any agreement, you're going to be good. As long as you make sure that whatever has to do with a particular geographic issue relative to the way that they administer their rules, policies, or, all of that stuff, make sure that, you're within their parameters. And usually it's pretty easy. Every city, every little town in America at this point has a website. They all have a housing office, and they all can tell you what their rules are, and you just compare them. You get, take you about an hour to go in there, compare theirs to yours, and make sure that your wording is correct. And oftentimes they'll have an agreement right on there. So if you need to change your wording, you can almost literally cut and paste to match up with their rules and procedures and policies. Anyway, long-winded answer. So anything we can help you with directly, Garrett, as far as, the club, what you can expect, anything to do with the agreements that we're going over, anything at all?
Just basically learning the legalities of it. This is not my favorite thing to do, but definitely needed. The first deal that I had put under contract a couple months ago, and Justin knows about this. It was actually, I had used a regular right to purchase contract. I didn't have a lease option contract. So I had just written it up as a purchase and sell agreement.
Contract.
Yeah. And unfortunately that deal didn't go through, but that's what I used at the time. So
Yeah. So, and thanks for bringing that up, because that's another reason why we're doing the contract, part of the training, is because a lot of people don't understand which contract goes with which deal. Which agreement should you put in place if you're trying to create this scenario? And just that little bit of understanding, and like you said, great point. This is probably everybody's least favorite part. Like I know that when I'm doing this, there are people in the audience that their eyes are glazing over. They're like, oh my God, right? But this is the ugly part of you being a strong, high quality, within, legal parameters, operating effectively, efficiently, and legally in your business. You got to know this. This is the part that nobody wants to know, but everybody has to know.
Right.
So you're right about that. It's the same for me. I'm literally doing this just to review all of the agreements and stuff myself, because, I need to know. And this is ultimately, when all is said and done, this is the only thing that's going to keep you out of hot water or possibly even jail. Right? This is the only thing. All of the noise that's being made by the NAR, National Association of Realtors, and all of that stuff, the buffer that we have between any arguments that they ever make is full disclosure and proper agreements, both written and delivered. Right? As wholesalers, that is our what do they call it? Our armor are those things, right? Is making sure that we are operating within the law with proper agreements, and most importantly, proper disclosure, right? Don't hold nothing back. Don't keep no secrets. Don't think that, they'll never find out. Because the minute you think that, that's when they find out, and now you're in a legal situation. Your whole business is on hold. You're at risk of losing everything. You're not sleeping at night. It is not worth it, folks. Just take care of all the business up front, and you'll be good. Any other questions for us, Garrett?
No, it's exciting to me. I'm excited. I'm looking to get my first deal done on the lease option side, and I'm just soaking up a lot of knowledge. Everybody's been helpful.
Good. Yeah. This is a great group, man. Anybody you reach out to, from the coaches to, the other members of the group, everybody is always willing to lend a helping hand. And even if the helping hand is simply pointing you in the right direction.
Can I say something here too, Coach Victor?
Yes, sir.
Nobody likes this topic.
Nobody.
I mean, you guys hear me whine all the time when you see me get into paperwork training and stuff, and I get all mumbly and I'll stutter and I'll tell you, this stuff makes me nervous and all that, so that's normal if you feel that way. No, I don't think anybody likes this, but the fact is that I can talk about lease option theory, cash transactions theory, ugly house stuff, subject to, we can get off into creative finance, and we can talk about the theory of all of these things all day long, every day for the next 5 years, and you won't understand it like you would if you just understood the agreements. If you understand, see, nobody likes this topic, but I promise you, if you crack this topic where you become proficient, I didn't say a master, but a proficient at agreements, you'll understand all these transactions for the most part. And the ones you don't understand, hey, hand me the agreement and I'll understand it in 3 minutes. Okay, so this is not to be neglected. That's all I'm saying. So I want to just encourage you that if you have inhibitions about agreements, get up its ass, beat this thing, and become very proficient at this, and you'll be head and shoulders above and beyond everybody else that that's trying to do this. Promise.
Yeah, absolutely. Absolutely right. And I don't think that there's none of you on here that don't know that, right? But like he said, this is the ugly, this is the walking on broken glass part of the business, right? Like nobody wants to do it. Nobody is excited about this. We even started off with people who we've lost since this started. And for the most part, it's just because it's like, it's legalese, right? Like, But, I appreciate the fact, Garrett, that you said, you're excited and I can tell by just your posture that you are just, a sponge and you're soaking up every bit of information and it's backed by a commitment to, be the absolute best that you can be at the game. Yeah, absolutely. And I think, for the most part, everybody in the club is that way. And I acknowledge everybody, taking it on and, doing the hard part. And then also, ringing the bell when the time comes and, getting that check. But you need all of this ugly stuff to be able to get to, that check. So appreciate everybody being here. We got about 5 minutes left. If anybody has anything else they want to, jump in here with, Justin, you look like you.
I want to say something again real quick.
Okay.
Sandra is in the room. Sandra, I tried to send you your bell, for the MVP of the year, and there's a gift card in here too. Okay, I got it returned to sender. They couldn't find you, Sandra. So I need you to contact me because I got a hole burning in my pocket and I want to spend this gift card. Okay, so you better speak up.
I hear you, Justin. Thank you. Yeah,
email me or text me or whatever.
Yeah, we just
Sandra.
relocated my business mailbox. It's UPS, but they just moved recently,
Okay.
so I'll email you.
Well, everybody's got theirs but you, so let me get you yours so you can
right.
at least have a little something there to.
Thank you.
All right, that's
To
all, guys.
signify your success.
Yeah, absolutely. Thank you.
All right. So let me just say thank you, Garrett, for showing up and getting your game tight. Sandra, thank you so much for being here. Always appreciate your support. Alan Bryan, always in the house. Appreciate your support. Corey Wright, hey, I see you turn your camera on. Always good to see you, my friend. I know you out there in the battle. And Aaron Pilot, I spoke to you a little earlier today, man. Thank you very much for your support all the time, you guys. And with that, we're going to call it a day unless somebody has a question or anything that they, that's burning and they need to get an answer for.
Yes, sir. Victor, I
Hey,
just want to ask a question, real quick.
Uh-huh.
Sandra, yesterday you had spoke about pulling up that gentleman's name about the non-for-profit. Was you able to pull that up, Sandra?
Yeah, I put it in the chat room yesterday for everybody.
Oh, I didn't get it. I missed it.
Who was it, Sandra?
It was Jordan Michael, the guy
Jordan
that had,
Michael. Thank you.
yeah.
Okay. All right.
Jordan Michael. Okay, thanks so much, Sandra.
You're
Not George
welcome.
Michael, the singer, though.
No, he was an investor. He has spoken to us, I think it was earlier this year, back in March. He was an
Okay.
investor that had spoken to us about how we can attract sellers, but he also has an arm. His organization also does nonprofit. So he was showing us how we can do nonprofit as well if we wanted to do a nonprofit side of our business. And he was getting grant money through Google ads, but he
Oh,
was
yeah,
saying
yeah.
that we had, yeah, do you remember him? We had to set it up in Canada or something like that.
I thought that was Jesse Mills.
No, Jesse Mills was a different guy. Jesse Mills
Okay.
was,
I thought Jesse was doing the Google grant thing. Okay. All right.
yeah, I think Jesse was he was the mortgage guy, right? He was showing us how to do that
Slow
flip.
Slow flip.
Yeah, slow flip guy.
lease option.
Yeah, slow release option guy. Okay. Yeah.
Yeah.
That's what he was. Yeah. Yeah. Because, we be bringing the noise up in this club. So there's a lot of opportunity. If you guys weren't on the call last night, with Mitch Stephen, as part of the Monday evening training that Steve Driscoll does, it was really good. So Justin has reposted the video, so make sure you take a few minutes and check that one out as well. Some really good stuff in there about how he uses creative financing and subject tools and stuff, and most importantly, private money to build a hugely successful business, hugely successful. So anyway, guys, with that, you guys have a great rest of the week. Thank you guys for showing up and showing out, and we'll see you guys again next week. All right.
Thank you, Coach
Okay, Victor. Thanks again
You're
for your
welcome.
help earlier.
You're welcome. Thank you, my friend. Love you
Thanks,
guys.
Victor.
I just
You're
had to
welcome,
bring it
Sandra.
myself.
Bye-bye.
You say that video was posted on the Facebook group or the YouTube, the one you just spoke about?
It's everywhere, man.
It's everywhere. Yeah, you can pretty much go to any of the Shut Up Money sites, and you'll find it on in the Facebook group, in the chat, everywhere.
It's the last one.
Yep, the last one from last night with Steve Driscoll's Monday night event.
Okay. Yeah.
All right, guys. Peace.